So for everyone here in the room, welcome to today's session of the ECLA Online Learning Center. My name is Marcus Schmidt, and I'm the General Manager of the European Company Lawyers Association, and I'm happy to moderate our interesting discussion for the next 60 minutes here. Today's webinar focuses on a very interesting topic. We shortly say LPP, but of course it's legal professional privilege for in-house counsel. Everyone here in the room knows about the ongoing discussions across Europe when it comes to privilege for in-house counsel. We also know the variety of jurisdictions and how they handle legal professional privilege is quite different across Europe as well. Today we will discuss those various developments in selected European countries and the recent judgment of the Rotterdam District Court. We are delighted to welcome today's speakers, which will provide valuable insight. I would like to thank our colleagues at Cleary, Gottlieb, Steen and Hamilton for supporting the European Company Lawyers Association and drafting a legal opinion for this very recent judgment in the Rotterdam District Court decision. And I'm very happy to have this webinar today with you. Also, it's going to be a very interesting webinar because for the first time, we are hosting a webinar with 8 speakers. Some housekeeping rules before we get started. Please feel free to use the chat function to the right, everyone, to ask questions. This webinar will be recorded and is also it's also possible to see this later on the ECLA website in the section Online Learning Center. And we will have a Q&A session to the end of the webinar. So hopefully all of your questions will be answered by the experts. Without further ado, I would like to welcome today's speakers, Robert Snelders, Richard Pepper, Jennifer Kennedy Park, Zunil Gadia. I hope your sound works now. All of them are from Cleary, Gottlieb, Steen and Hamilton, today's partner for the webinar. Would also like to welcome Clarissa Freundorfer, who is the chairwoman of our member association in Germany, the in-house counsel group at DAV. And I would also like to welcome Simon van der Putten, who is Secretary General of our member association in Belgium, IBJ-IGE. And I think we have Herman van Hecke from IBJ-IGE on board as well. And of course, last but not least, ECLA's president, Jonathan Marsh, will also be speaking. And Jonathan, I hand the microphone over to you, the virtual microphone.
Okay, thank you, Marcus. Well, good afternoon, everyone. It's really a pleasure to take part in this webinar on this important topic of legal privilege for in-house counsel after this important decision in the Shell-Etosha case. And I would also like to reiterate what Marcus said and thank the Cleary team for all their work on the ECLA brief, particularly Robert Snelders and Richard Pepper, who are with us for today's webinar. So as Marcus mentioned, the European Company Lawyers Association has been promoting LPP for company lawyers in Europe for almost 40 years. We started in 1983. And there's still much work to do, unfortunately. But I'd like to start by providing the main policy reasons that we are advancing LPP for company lawyers, and then briefly discuss the legislative reform in Spain and the current situation in France, before handing off to Clarissa, who will address the German situation. So in terms of policy arguments, the lack of LPP for in-house counsel is really a persistent problem that we've been experiencing in the in-house counsel profession in Europe and in the larger business world. LPP, of course, allows a client to exchange information without reservations to a trusted legal advisor to obtain advice and counsel, and then receive back legal advice and counsel without reservations. So LPP is currently accepted in a majority of jurisdictions in EU member states, but some significant exceptions remain, particularly in France and Italy. LPP is a valuable tool in a properly functioning corporate legal department, and the lack of LPP has 2 disadvantages. First, we think it interferes with proper function of corporate compliance. It has a chilling effect on management. It tends to cause them to avoid disclosing sensitive information. And so we want to remind authorities that in-house counsel want to help their companies comply with the law. And secondly, it puts EU companies at a disadvantage against companies that operate where LPP is respected for in-house counsel, and it impacts the proper functioning of the single market. So when an EU authority seizes documents from in-house counsel, those documents can be shared with governments or even with private litigants in subsequent proceedings. And with knowledge of this risk, companies will be more likely to either consult exclusively outside counsel, which results in increased costs and inefficiencies, or worse, consult no one, rather than disclosing sensitive matters to their in-house counsel. There's also the point that LPP is really a matter of European fundamental rights. Article 16 of the Charter for Fundamental Rights of the EU recognizes the right to conduct a business in accordance with community law and national laws and practices. National law and practices now allow for the assertion of LPP to protect legal advice from in-house counsel in a number of member states. Those states have determined that the existence of an employment relationship between the client and his lawyers does not compromise independence or objectivity of professional judgment. ECLA recognizes that this independence argument is critical in this debate, and we have tackled it head-on in a white paper called Independent by Design, which is right here. It's an ebook. You can download it on the ECLA website, and I encourage you to take a look at that. So that's what I wanted to say on the broad policy issues. Now just to say a few words about the situation in Spain and France. In Spain, just last week, on March 3rd, the Spanish government approved a new general law governing the Spanish legal profession. The statute modernizes the legislative framework on a variety of topics, such as freedom of movement in Europe for lawyers. And on the topic of interest to us, the statute provides an exhaustive overview of the right to professional secrecy for lawyers. And in particular, for the first time in Spain, the legislation clarifies that lawyers can practice in-house as employees under a standard employment agreement. And the agreement will stipulate that the employing company must respect the freedom, independence, and legal privilege of the employed lawyer. So this law is really a landmark. It clarifies, though, the existing practice, which is that Spanish company lawyers have been practicing in-house for years in the same way as you would in the US or in the UK, but without explicit legislative approval. And so this is a real significant development in continental Europe. And it contributes to ECLA's overarching goal of establishing a pan-European recognition for rights of in-house lawyers equivalent to the activities of lawyers that work independently or in firms. Now, another significant aspect of this Spanish law is that it could come into conflict with the 2010 EU Court of Justice ruling in the AkzoNobel case. This case determined, of course, that when a commission investigation on competition law matters is underway, in-house counsel advice may not be privileged. The main justification was, again, that in-house lawyers purportedly lack the requisite independence of outside counsel. And that, in fact, that decision is what led ECLA to prepare the white paper, Independent by Design. Now, turning to France, things are not quite so bright. Many expert reports have been commissioned by successive governments over the past 30 years in France. All of them recommended to reform the law to ensure the advice of
I don't know what to do about that, but I'm just going to have to present without any more
legal privilege. Unfortunately, none of these attempts have succeeded thus far. The latest report was led by French Deputy Raphael Gauvin, issued in 2019. And the title of the report is quite interesting. It's to reestablish the sovereignty of France in Europe and protect our companies from laws which have extraterritorial effect. And so that was really the axis of the main axis that the Gauvin report worked on, and they recommended to create the LPP for in-house lawyers. And indeed, the current Minister of Justice, Dupond-Moretti, made such a proposal last fall. And ECLA has been active in supporting this reform along with the French member associations, AFGE and the Cercle Montesquieu. And in particular, ECLA issued a letter clarifying the situation in foreign jurisdictions to provide evidence to France that the system works very well elsewhere. Unfortunately, the local bar associations throughout France have been very vocal in opposition. Their main fear is that 20,000 in-house lawyers will descend on the bar and compete with outside counsel. It's a very Malthusian approach, but that's it is what it is. And in addition, there's a very unfortunate coincidence. The recent condemnation of former President Sarkozy to 3 years in prison for corruption has not helped. The president was accused of trying to obtain details in other legal proceedings implicating his name by using his lawyer, his outside counsel, to propose a prestigious promotion to a judge who was working on those affairs. And unfortunately, Sarkozy's and his lawyer's phones were tapped, and the evidence was used in the case against the president. And his defense argued in vain that those conversations should be protected by legal privilege. And of course, there's no connection with the in-house legal reform in France, but the French prosecution division is fiercely opposed to allowing in-house counsel from having LPP, particularly in criminal matters. And the Sarkozy case gave them the opportunity to point out that LPP shouldn't be available even to outside counsel in certain French criminal prosecutions. So it's a setback, a temporary setback, I hope, in France, but we're confident reform will ultimately prevail in France on this topic. So that concludes my brief remarks. Thanks for your attention. And Clarissa to address the current developments in Germany.
Thank you very much, Jonathan. Thank you very much, Marcus, for having me today and for being able to say a few words on the development of legal professional privilege for in-house counsel in Germany. I can relate to a lot of what has just been said regarding France, because I think we have, or did have, a quite similar situation as in France until 2016, where we were fighting for being acknowledged as real lawyers, being company lawyers. And indeed, we succeeded in this. And since 2016, there is a specific law acknowledging company lawyers as being lawyers. And those company lawyers are by legal definition independent and not subject to instructions by their employer. So in a way, by this law, we now fulfill the requirements of the Akzo Nobel judgment of the European Court of Justice of 2010. However, the problem is that this law of 2016 explicitly refused the criminal legal privilege for in-house company lawyers. And the legislator in 2016 quite extensively motivated why it thinks that in-house counsel should not have the legal privilege. According thereto, giving the legal privilege to the in-house counsel would hinder an effective criminal law enforcement and would create the danger of prosecuting authorities not having access to relevant evidence. So what the legislator is implying thereby is that companies could use the offices of their lawyers to hide away incriminating documents. And I think we all know that this is absolutely not the role of company lawyers. Rather, as Jonathan already pointed out, the company lawyers are there to help the company being compliant. And for being able to do so, you need a secured room where you can talk between lawyer and client and be sure that the document and the information can not be used by the prosecuting authorities. So that's the situation we are currently in, and unfortunately there's little hope that this will change in the near future, because there is currently a draft law in Germany which is in the process of becoming a law, which is even narrowing down the legal privilege for external counsel, and which in its reasoning is underlying again the importance of effective prosecution, which is allegedly harmed by legal privilege. So not a very encouraging situation currently, similar as in France, but we are not deterred from fighting for getting the legal privilege in the end. And I think there are quite promising developments in other countries, like we just heard in Spain and like we will hear now from the Netherlands. So this might give an impetus to the German discussion as well. Thank you.
Thanks a lot, Clarissa. And I know that you are very, very active in DAV in Germany to support the role of the in-house counsel in that country. Now we would like to hear from Belgium, a country where legal professional privilege is granted to in-house counsel. So Simon, the floor is yours.
Good afternoon, everyone. So my name is Simon. I'm Secretary General at the Belgian Institute of Company Lawyers. Thank you for having us today. In 5 minutes, I'm going to give you a quick overview of the current state of LPP and the developments in Belgium. So in Belgium, the profession of company lawyer is regulated by a standalone act passed in the year 2000, so 20 years ago. If you work as in-house counsel for a company which has part of all their activities in Belgium, well, you can choose to join our institute. We now have around 2,100 members. If you choose to become a member, you hold the protected title, company lawyer, juriste d'entreprise in French, or bedrijfsjurist in Dutch. And then you're also submitted to the code of ethics, under which you must, among other things, remain intellectually independent. And this requirement is enforced by our disciplinary bodies, which are shared by magistrates. And we have recent decisions of this enforcement in October 2020. You also have, so if you remember, the legal professional privilege under Belgian law, LPP. As you can read on the slide, our LPP is provided by the law of 2000 itself, which says that advice for the benefit of the employer is confidential. Confidential meaning it cannot be seized by authorities. You can also see on the slide that our LPP has been confirmed by some Belgian courts since almost 10 years. But in this case law, however, it was held that we don't have full professional secrecy, what is called in French secret professionnel, unlike, for example, attorneys have or doctors. We only have, but we're happy to have it, but we only have confidentiality based on Article 8 of the European Convention on Human Rights, according to the court, so under the right to private life, not under Article 6 of the European Convention on Human Rights, so not under the right of legal assistance. Why did the court decide so? Because in the explanatory statement of our law back in 2000, it was specified, it was written in these statements that company lawyers could not have the same LPP as external lawyers, as attorneys. This was mainly led by the pressure of the Belgian bar associations back then. So while we both give legal advice to companies, attorneys have a stronger LPP than us, and the main difference is that we have no criminal sanction. So if a company lawyer breaches his duty of confidentiality, there's no criminal sanction to that. That's the main difference. So 20 years after our institute was created, there was a need to modernize our profession. So actually a bill has been filed last December by members of the parliament. The bill is currently in discussion. We want to modernize different points, such as our governance or disciplinary rules, where there are two big changes in this bill. The first is that certain self-employed individuals should be able to become a company lawyer in Belgium. Our profession is currently open only to employees, so under an employment contract. Why do we want this? Well, the first reason has a link with the Shell case, where the Dutch court confirmed, I will hear about that later, that in-house counsels can have LPP even if they sit in executive boards. In Belgium, well, you are legally required to be self-employed if you sit in certain executive boards. So if in-house counsels sit in such a board, they have to be self-employed and they cannot become a company lawyer because the law says they have to be employees to become a company lawyer. So that was not okay for us, and I think the Dutch court agreed with this standpoint that it's not okay. Another reason is that there are more and more temporary company lawyers doing exactly the same job as employees, but they accept that they are not employees, they are self-employed. For example, for replacements in case of medical leave, legal interim managers, or now in COVID times when small companies seek some temporary work from a company lawyer for a few months, for example. And the second big change we want is to strengthen our LPP. What do we want and why do we want it? Well, we want to repeat in our law, to enact in our law, the case law on the scope of our LPP. So not only the advice is protected, but also the request of advice, the draft advice. This gives legal clarity, legal certainty. We also want to have a definition of legal advice in our law, meaning advice on the legal position of the company, but we also advise as to whether or not to enter into proceedings. And we follow up those proceedings, even though we don't plead before the courts. Only attorneys can represent companies in courts, and we're not changing anything to this. We just add this definition, and that's important for us because this makes a link with Article 6 of the European Convention on Human Rights, namely that we company lawyers contribute to our company's right to legal assistance under Article 6. And finally, and last but not least, we add in the law of 2000 itself a criminal sanction for the company lawyers who would not respect their duty of confidentiality. This is necessary to ensure that our LPP will be fully recognized in a sustainable way in the future, to ensure all the Belgian authorities recognize it and respect it. And also now, for example, the US in-house counsel mostly required to communicate with an external attorney, as they believe our LPP for company lawyers is not strong enough because it has no criminal sanction right now. So that is a summary why we want this stronger LPP. To conclude, I'd like to say that, well, in our discussions to hope to get our bill passed, we stress that the company lawyers are actually serving the general interest. We promote legal compliance within our company. And this requires a strong LPP to ensure our colleagues, our managers, find their way to the company lawyer, to ensure they involve us in projects and get our advice. So this is it for Belgium. Thank you, and we'll be happy to answer your questions at the end.
Thank you very much, Simon. That's really very, very interesting. Before we come to our questions at the end, we have a couple of other countries to speak about, and I hope that it works with the sound now. Sunil, I hope you can hear me and you can activate your microphone. We would be very interested to hear how the situation in the United Kingdom is.
Afternoon, everyone. I hope you can hear me clearly. I'm having sort of technical difficulties at my end. I can't really hear anyone on your side, but I gather you can hear me, so I'm going to carry on with a quick overview of the English law of privilege. I'm going to make three introductory comments first. I'll then talk about the three categories of English privilege law, and I'll then take a deeper dive into the two most prevalent categories. So three introductory comments to begin with. Firstly, English privilege law is a very intricate area. Secondly, it's not very intuitive, as you will see when I go through it in a moment. And thirdly, when it's tested in the courts, it often produces unpredictable outcomes. And with more of the litigation in the English jurisdiction being funded by litigation funders and less control of litigation by those paying for it, we tend to see more frequent challenges to privilege claims. So this is a fairly developing area. Those are the three introductory comments I wanted to make. Three categories of privilege. If we move to the next slide, we have three categories: legal advice privilege, litigation privilege, and working papers privilege. So starting with legal advice privilege, as you see there, it protects confidential lawyer-client communications or documents evidencing those communications made for the dominant purpose of obtaining legal advice. And to break that down, there are four components. Firstly, the communication needs to be confidential. Secondly, it needs to be between a lawyer and a client. Thirdly, made for the dominant purpose of giving or obtaining legal advice. Now, I'm going to say a little bit more in a moment about who is a lawyer and who is a client for these purposes, and that's where the the area of uncertainty and controversy arises. So I'll come back to that in a moment. Second main category we have of privilege is litigation privilege. And as you see there, it protects confidential communications where adversarial litigation was in reasonable contemplation and which were created for the dominant purpose of litigation. So again, breaking that down into its four components, you need confidentiality, you need adversarial litigation in play, which is in reasonable contemplation, the third component, and the document needs to have been created for the dominant purpose of that litigation. So that's the fourth component. And I'll say a bit more in a moment about what is adversarial for the purposes of this privilege category and in what circumstances litigation is considered to be in reasonable contemplation. Before I do that, the third category, working papers privilege, you don't see a lot of activity or action in this area, but very broadly, it protects documents which, although they may not have been communicated to a client, would betray the trend of advice that a lawyer may give. A classic example is lawyers' research notes, internal research notes. As I say, not particularly controversial. You don't see that very much, so I won't say much more on that. But if we move on to the next slide, what I'm going to do here is just unpack one of the components of legal advice privilege. As I said, you need a communication between a lawyer and a client for the purposes of this category of privilege to arise. So who's a lawyer? Well, on the left-hand side, you see includes overseas lawyers, in-house lawyers, non-legally qualified personnel, paralegals, for example, where that person was acting under the supervision of a qualified lawyer. So far, so good, nothing particularly controversial. Who is a client for these purposes? This is where it gets tricky and unintuitive, because under English law, who is regarded as a client for the purposes of the communication has a narrow and somewhat artificial definition. And it's limited to a class of employees within the organization with express or implicit authority to seek and receive legal advice on behalf of the company. Only that group of personnel qualifies as the client for the purposes of legal advice privilege. And in a relatively recent case, that was given a very narrow definition as the group within the client who constitute the directing mind and the will of the organization. This is pretty controversial, and it's been criticized broadly in legal circles, but still upheld and remains clear English law. And so what it means is that the courts, when this category of privilege is challenged, pay close attention to who it is at the client organization that the lawyer has had a communication with. And in particular, is it somebody who is considered to be within this narrow category of individuals who have authority to obtain, seek and receive legal advice. And that in large organizations creates some complication. And in our experience, clients deal with this in different ways. They manage this in different ways, which if there were more time, I would talk about a bit more. But that's really the central area of risk for legal advice privilege under English law. If we then move on to the next slide and we look at litigation privilege. Here, as I mentioned earlier, this doesn't require communication between a client or lawyer. It can apply to communications between a client and a third party. But in order for litigation privilege to apply, you need adversarial proceedings. The documents have to be created for the purposes of adversarial proceedings, which are in reasonable contemplation. And those two issues give rise to some uncertainty. They're questions of fact. Adversarial, for example, doesn't include an internal investigation. This is the key area of risk for you. So if a business does an internal investigation because a conduct issue arises, that isn't regarded as adversarial for the purposes of litigation privilege. And so if subsequently you are involved in litigation raising the same issues, your internal investigation material isn't protected by privilege. And the other final point I'll make is reasonable contemplation has to be something fairly real. You can't just say, well, I thought somebody was going to sue me. There has to be a real prospect that you are going to be the target of litigation for litigation privilege to apply. So I'm going to pause there and hand over to Jen. And as Jen talks about US privilege, you'll see how in the field of investigations in particular, there's a pretty stark difference between UK and US privilege law. Jen.
Thank you, Sunil. And I think what I would like to do, just introductory points, is try to make some contrasts to the UK privilege regime as I talk about the US regime. As you'll hear, it is in framework quite similar to the UK regime, but is far more expansive. In fact, I think of all the jurisdictions we're talking about today, the US has the most expansive definitions of attorney-client privilege and attorney work product, which are the ways we frame it in the United States. The other introductory point I would make is that in the United States, our interpretations of our attorney work product doctrine and our attorney-client privilege are governed by a complex system of federal and state court rulings. And so to really understand how attorney work product doctrine applies or attorney-client privilege applies in the United States, you need to know in which jurisdiction you are litigating first in order to consult the laws of that jurisdiction, because there are differences in different jurisdictions in the United States. So there are two forms of privilege essentially here in the United States, the attorney work product doctrine and the attorney-client communication privilege. Our attorney work product doctrine is very similar to just what you heard Sunil talking about in terms of the UK. It was established by U.S. Supreme Court precedent in 1947, and the idea is it protects the working thoughts and work product of lawyers. That includes all in-house lawyers. There are no limitations for in-house lawyers. For the privilege to apply, it has to apply to a document or a tangible thing. It has to be prepared in anticipation of litigation and be prepared by or for a party or by or for his representative. I just want to pause for a minute to talk about number two, which is prepared in anticipation of litigation. As Sunil said, in the United Kingdom, there is a great deal of controversy as to what that means. In the United States, it definitively includes internal investigations. As Clarissa was saying, I think earlier, part of the thinking around this is that you want to be able to protect lawyers in-house who are giving a company advice in anticipation of what may ultimately be uncovering wrongdoing. And so the thinking is that it will apply to in-house lawyers for that reason. In addition, it also applies to criminal and regulatory proceedings, even where the company at issue has not been identified as a target of the proceedings. And I know that this contrasts with how it is interpreted in the United Kingdom. In the United States, for example, our Department of Justice classifies those who are subject to their investigations as either witnesses, subjects, or targets. A target meaning someone who is clearly under scope for potential criminal indictment. A subject is someone who could potentially be under scope for criminal indictment, and a witness is someone who is not under scope for potential criminal indictment. And the anticipation of litigation covers all three of those types of proceedings with the Department of Justice. So as I noted, very expansive. Now we can turn to talk about quickly attorney-client privilege. Which, as you see here, has been spoken about extensively by our Supreme Court in the United States and is considered to be quite sacrosanct. It applies to all lawyers admitted to the bar and anyone working on their behalf. Again, incredibly expansive. This means all lawyers at an in-house company as well. Paralegals, secretaries, translators, experts, even press relations consultants in some occasions can be considered covered by the privilege. Similar to what occurs in the United Kingdom, it requires a confidential communication between a client, including a corporation, and counsel for the purpose of giving or receiving legal advice. And when we say between a client, including a corporation, in contrast to how it works in the United Kingdom, every individual employee of a company that is receiving advice from an in-house lawyer is considered to be part of the client. So it is not just, for example, senior managers, or for example, those who are making decisions about a particular legal decision or a legal course of action. It includes all employees. And if we just talk a little bit about the areas in the United States on the next slide where we are seeing privilege not applying, and one that I think is quite important, particularly for in-house lawyers. So the first is communications made in the presence of third parties outside the attorney-client relationship. Obviously, there's a waiver there. There has no confidentiality if you're not just communicating between the attorney and the client. And critically, the second one, which is communications made for the purpose of rendering business advice, are not considered covered by our attorney-client privilege in the United States. And what that means is that if you're an in-house lawyer who routinely is involved in business conversations or sits in business meetings, and you are called upon to both weigh in on those business decisions from a legal risk perspective, but also potentially render legal advice or legal judgment, there is the potential that those communications are not covered by the attorney-client privilege in the United States. The way the test is written to determine whether that communication would be covered or not is that the legal issues have to be predominant in the conversation. Thirdly, underlying facts are not covered by our attorney-client privilege, meaning you can't take something, a fact or a document that was not privileged and send it to a lawyer and have the lawyer therefore cloak it in attorney-client privilege. I think that's something that sounds like it is an issue in Germany and a concern in Germany. And lastly, the communications as to which privilege has been voluntarily waived cannot be part of the attorney-client privilege. And this is very controversial here in the United States at different periods in our history when our authorities used to routinely ask corporations to waive the attorney-client privilege in order to get cooperation credit from the authorities. There was a real push from the defense bar here in the United States to cease that. And as of now, the US authorities, for the most part, require senior level permission in order to seek waivers. Now, that's true in the United States, but if something that we believed was privileged is turned over to an authority in a different jurisdiction that did not believe it was privileged, the US authorities can capitalize on that. So I have been involved in cases with Sunil where documents that we would have considered privileged in the United States were provided to UK authorities, and the US authorities were able to obtain those documents from their UK counterparts, despite the fact that they would not have been able to obtain them in the United States themselves. And I think I'll turn it back over to my colleagues to talk about the European Union.
Thanks a lot, Jennifer. We are still very much in time with our script for today, so I immediately hand over to Richard and Robert to elaborate on the European perspective, especially in competition investigations, and of course the Rotterdam case, which we are all here to discuss.
Yes, thanks very much, Marcus. Before I'll turn it over to Rich to deal with the recent Rotterdam District Court judgment, I'll finish our tour d'horizon by briefly recalling the privilege rules at EU level, which are relevant mainly for EU competition law proceedings. As most of you will have realized when hearing the previous speakers, compared to the UK, US, and other national sets of privilege rules, EU privilege rules remain fairly simple or simplistic, if you will, with relatively little case law. And it can be resumed around the three principal cases that have been rendered and that are well known, AMNS, Hilti, and AXO, as covering written communications with external counsel entitled to practice within one of the EEA member states that are connected to the client's rights of defense. Secondly, internal notes reporting legal advice from external counsel. And thirdly, documents produced exclusively for the purpose of seeking legal advice from external counsel, but irrespective of whether they were actually exchanged or created for the purpose of being sent to an external counsel. So the scope of privilege rules at EU level is limited in several respects, and the Commission has by and large taken a narrow view of it. Most importantly, for present purposes, in-house counsel advice is not currently protected at the EU level, and the Commission does not generally accept derogations from that principle, including in situations where in-house counsel advice enjoys privilege in the jurisdiction in which it was rendered, say the United States. And so, if you look at the little table on the chart, in a simple way, in-house counsel advice not protected. That's pretty strictly applied. In a distant past, we have been able, in certain situations, to persuade the Commission to adopt a data room procedure where they would go in and look at US in-house counsel advice, select what they thought was relevant, and the rest would not find its way into the file. It's not clear whether they'd still be amenable to that. Generally, the only thing that they are amenable to today is a formal decision compelling the provision of the in-house counsel advice, so that at least there is some protection against a waiver of privilege in other jurisdictions, notably the United States. Another limitation that is maybe not always realized as clearly is that even with external counsel advice, it is only advice that relates to competition law that is protected, and that can be enforced where relevant. The Commission has seized external advice relating to non-competition law matters that is relevant to their competitive assessment, be it patent attorneys or employment advice or others. Finally, one interpretation of the case law is, as I said, that only the advice of external lawyers admitted to the bar in one of the EEA member states is protected. That, fortunately, the Commission is taking a more permissible view on, and that's very rarely enforced. I mean, generally, the Commission accepts that all external counsel advice that meets the criteria will benefit from privilege. So with that, I'll turn it to Rich to discuss the implications for all of this of the Dutch District Court judgment.
Thanks, Robert. So I'm going to talk you through the recent Rotterdam District Court's judgment relating to Shell, and also ECLA's involvement in that process, and the ways in which we supported ECLA during the procedure. By way of background, the underlying case related to some bribery allegations regarding a Nigerian oil field that led to a criminal investigation by, amongst others, the Dutch public prosecutor against Shell. And as part of that investigation, the prosecutor seized various documents from Shell, including documents which related to or included communications with 15 in-house lawyers. Shell claimed that seizure was unlawful because the relevant communications were protected by privilege, and so the matter was referred to a Dutch magistrate to rule. The Dutch magistrate distinguished between lawyers who were established in the Netherlands and those who were established elsewhere. As regards the lawyers that were established in the Netherlands, the magistrate's ruling focused on a requirement under Dutch rules for in-house counsel to sign what's called a professional statute for employed advocate, which provides for respect for the independence of the lawyers, notwithstanding their employment contract. And in theory, that should be entered into, on the one hand, by the lawyer, and on the other hand, by their employee. However, none of the lawyers at issue had actually signed one of those professional statutes.
So that was the first reason that the magistrate used to conclude that the in-house lawyers established in the Netherlands did not benefit from LPP. Perhaps more worryingly, the magistrate also noted that Shell's head of legal sat on the company's executive committee, and the magistrate claimed that that undermined the independence not only of the head of legal, but also the entirety of Shell's legal function. Then as regards the foreign in-house lawyers established outside the Netherlands, the magistrate conceded that they could benefit from LPP if they did so in their home countries, but again referred to the membership of the head of legal at Shell on the company's executive committee, and concluded that undermined their independence in a way that jeopardized LPP protection. So Shell appealed that finding to the Rotterdam District Court, and the matter came to the attention of ECLA and ourselves, and we supported ECLA in submitting an amicus curiae brief in support of Shell's appeal. So what did the brief argue? Well, first of all, ECLA argued that LPP is of fundamental importance both for in-house and external counsel. It encourages full and frank communication between an attorney and client. Dutch law, in fact, recognizes LPP for in-house counsel. And indeed, in-house counsel are often more effective way of dealing with legal challenges than external counsel, insofar as they know the business that they're supporting inside out. Secondly, and I think this is probably the most important part of the appeal from the perspective of ECLA, we challenged the idea that the membership of the head of legal in the executive committee undermined their independence and also undermined the independence of the whole legal function. And in doing so, we made the point that presumption was affirmatively unhelpful. In-house counsel are subject to the same professional ethics rules as external counsel, and membership of a board or executive committee certainly doesn't undermine the relevant ethics rules. And if anything, it does the opposite, because putting the general counsel on a board or executive committee makes it clear that legal compliance is of fundamental importance to the organization, increases the visibility of advice from the general counsel throughout the company. And it may even be that a general counsel sitting on a board has better employee protection than their counterpart who doesn't sit on the board in a way that would actually affirmatively support their independence. More generally, we made the point that membership of an executive committee helps a general counsel to promote legal compliance. Being on a board means that the lawyer will be well informed, understand decision making, and be able to respond in a quick and effective way to issues as soon as they arise. And actually, on the facts of the case, Shell's general counsel was a member of the executive committee as part of a 2004 settlement with the SEC in the United States. And so it would have been affirmatively unfair to conclude that jeopardized LPP protection for the entirety of Shell's legal department. And then we concluded really by saying that depriving Shell's legal department of privilege would be a poor policy choice for the Dutch legal system and business community. Denying privilege would violate fundamental legal principles under the ECHR. And we also encouraged the court to recognize privilege for foreign in-house counsel registered with their home bar. And we did so on the basis that it would be unduly burdensome to expect non-Dutch lawyers to be able to sign the necessary professional statute, and that it would be not unreasonable to require multinationals to only employ Dutch lawyers. And finally, noting that international comity principles should encourage countries to recognize each other's rules where appropriate. So how did the court decide? Well, the court started by confirming that countries should be free to regulate rules for lawyers and their practice as they see fit. And the court noted that the Netherlands has done so in the following way. It's held that independence is determinative for establishing LPP protection for lawyers. And then the Netherlands has supplemented that with a provision that says that independence can only be guaranteed when the lawyer and their employee enter into a professional statute. And the court held that that professional statute was decisive in determining when an in-house lawyer would or would not benefit from LPP in the Netherlands. So how did that manifest itself? Well, the court said, well, all the lawyers who are registered in the Netherlands who have not signed a professional statute, unfortunately, do not benefit from LPP. However, the court did not make any implications, draw any implications about the membership of the General Counsel on the board of Shell. And helpfully, the court also recognized that where lawyers were established elsewhere, outside the Netherlands, they should be subject to the LPP rules in those jurisdictions. The majority of the lawyers at issue were working in the United Kingdom, where, as Sunil has explained earlier, in-house lawyers are entitled to privilege, and so the court upheld those privilege claims. In one case, a lawyer working in Switzerland was denied privilege because in-house lawyers in Switzerland are not entitled to LPP protection as a matter of Swiss law. So just to conclude some observations on the judgment, looking narrowly at the Netherlands, it's now very clear that all in-house lawyers in the Netherlands, whether or not they're Dutch counsel, must enter into a professional statute to benefit from LPP protection in the country. Conversely, Dutch companies can employ counsel outside of the Netherlands, and where they do so, they're not subject to the relevant Dutch LPP requirements. But I think the case actually has some broader implications, even going beyond the Netherlands. First and foremost, the judgment made no reference at all to the notion that membership of the board or an executive committee might undermine privilege protection. And at least from my perspective, that's the most important part of the case. And it's really fantastic to see that part of the magistrate's ruling was disregarded. Interestingly, the judge in the Rotterdam court did not make reference to that, perhaps as a matter of professional courtesy, but it was clear that the judge did not find that to be of any relevance. And then more generally, I think this is a helpful step along the path of furthering LPP protection for in-house counsel. But I do think it bears some emphasis here that the relevant rules, at least according to this judgment from the Rotterdam court, will vary based on where a lawyer is registered and where a lawyer is working. And so it's going to be important, and perhaps increasingly important in a post-COVID world, for companies to remain alert to the local jurisdictional rules where their lawyers are working and registered, and make sure that they're at least cognizant of the implications of the location of their lawyers for privilege protection within the company. And Marcus and Jonathan, I think that takes us to the end of what we were planning to say. So I don't know if you want to open the floor to any discussion.
Yeah, thank you very much, Richard and Robert, and thank you, of course, to all the speakers. I'm very excited, apart from the content of today, that we also managed to keep our time schedule here with 9 speakers. I think that's really an experiment that worked out. Yeah, so as I said, thank you very much. We got some questions already on the chat, and I couldn't phrase it better than Thomas did in a question asking, do you see a shift towards a harmonization of legal privilege in Europe for the benefit of company lawyers and, of course, the management of the companies? So, Richard, since you were the last one to speak, maybe I direct this question to you first. Do you see maybe really a trend for harmonization in a positive way on a high level with legal privilege in Europe?
I think we do. Robert and I were in fact discussing yesterday that the European Union's approach to privilege is still governed by the AM&S case, which is now looking rather outdated. But in that case, the European Court looked at the privilege rules in member states and concluded that the broad trend of what they shared was that in-house counsel did not benefit from legal privilege. And I think over the years that have followed that case, we have seen a greater recognition of LPP protection for in-house counsel. As Jonathan said at the beginning of the session, that trend is moving in real time. Just last week we've seen the introduction of a greater recognition in Spain. This Dutch judgment is highly supportive of that. So as with a lot of these things in Europe, it'll remain a patchwork, I think, for years to come, unfortunately. But the direction of travel is clearly the right one. And I think we should all be appreciative of ECLA and their efforts in supporting that direction of travel and looking out for opportunities like this case, where there's a moment to push the ball in the right direction. But others may have other views.
Thanks, Richard. Jonathan, yeah.
Yes, maybe I'll just add something. I agree completely with your response. As I recall, the MS decision, when that was made, the EU had just accepted a number of new member states in Eastern Europe, and in a lot of those jurisdictions, the legal profession had kind of stagnated in kind of a time. Frozen in time to post-World War II time, and so they hadn't really had an opportunity to update their practices to what you see in Western Europe and other jurisdictions. So I think that when they were measuring the number of jurisdictions that recognized privilege and did not, it was overwhelmingly negative. And I think now there has been quite a bit of evolution, and it would be nice to be able to have a test case go back, and challenge maybe return AMS on the grounds that the majority now do recognize privilege for in-house counsel.
Thank you very much. We have another question which I would like to direct to either Robert or Richard here. We have a question from Gordon asking, with reference to the Jet 2 case in the UK, where the court basically decided that legal privilege, if it comes to legal questions, legal advice is privileged, but commercial or policy advice is not privileged. That was basically the ruling or the distinction in the Jet 2 case in the UK. Was this something the Rotterdam District Court touched upon as well?
I don't believe it did, and it's difficult actually for us to comment on this point, because we, at least as supporting an organisation that submitted an amicus curiae brief, have not seen the documents at issue. So our argumentation was focused on points of principle rather than that issue. But it's really an interesting point, and it's one that Jennifer commented on during her session a little bit earlier. Jen, I don't know if you've got any other observations about how this issue is dealt with in the US.
Yeah, I mean, in the US, unfortunately, it's a quite fact-specific determination. But one thing, thinking about the example of a lawyer, for example, who sits on an executive committee or a senior management committee, is to have clear agendas for when legal discussion is had, so that you can kind of separate out in the agenda what constituted the legal advice, similar to the way you would in a board of directors. But as I mentioned here, the test is one of predominance. And so if the predominant discussion was about the legal issue, it's considered to be legal advice. That in some occasions, we actually are looking at this on like a document by document basis.
I also heard that there is, wasn't there a Marriott case with Marriott Vacation Clubs a couple of years ago in the US that touched up on this as well?
There's a whole host of cases that touch upon this, right? And out of which comes the notion of predominance. And there are real sensitivities around the idea of sort of senior lawyers participating, similarly to what we just heard in the Shell case, in business making meetings.
Great. Thanks a lot. I think we have two more questions coming in. Let's see for a second, but I think for the time being, we can all agree that hopefully we will continue this webinar session, and then one day we will have a webinar where we all clink our glasses and congratulate for having a harmonized legal privilege, of course, on a high standard in Europe as well. So I see that still a question might come in, but maybe we can take this later offline also. I would like to thank all the speakers for today. It was a pleasure listening to you. And here comes the question. So maybe we take this as the last question. Sorry for this interruption. No, that's not a question. So that's fine. We keep it like that. And the slides that you have seen will be shared after our webinar, most probably tomorrow. So you can further elaborate on that. And I think the speakers are also available if questions come up in a later stage. So again, thank you very much. Thank you, Clary Gottlieb, also the colleagues for supporting ECLA with the amicus curiae in the Rotterdam case. And we're happy to see you in one of our later sessions this month as well, or even in the future in the ECLA Online Learning Center. So thank you very much and have a great afternoon. Stay healthy.
Thank you very much.